Good afternoon, and welcome to Public Health and Minority Health Disparities Subcommittee Part 2. We have two bills on the agenda. Today, these were, we talked about them briefly this morning, but everybody needed a little more time. So we are revisiting them. We're going to start with House Bill 290, which is the Office of the Chief Medical Examiner's Disclosure of Autopsy Information and Maintenance of Investigative Database. We thought we were very close. Wait, actually, do I have? I don't see 290. So let me actually flip that, and we're going to start with House Bill 386, which is pesticides, PFAS chemicals prohibitions. As we talked about this morning, we do not have consensus amendments on this, but I did want to give Delegate Hutchinson, Delegate Hill, Delegate Warman the opportunity to talk about the work that has been done, where this amendment language came from, and what we are doing, how we are helping with this bill. So Delegate Hutchinson or Delegate Hill, do you want to start and talk about where we started from, where we are, and how we got here?
Since I started in the meeting this morning, why don't I defer over to Delegate Hill?
I thought you did such a fine job. So basically, where we are right now, we listened to both sides. We asked them to come up with stuff. They came up with stuff. They couldn't agree on very much of anything. We looked at Minnesota and Maine, came up with what we thought was reasonable. Part of the issue, one of the main sticking point for the proponents is they want a definition for PFAS and pesticides that we use for firefighting foam and mattresses and carpentry and that kind of stuff. The challenge for the opposition is that whereas firefighting foam has one purpose, right? To slow the elevation of the temperature and keep you safe. Pesticide chemicals have multiple purposes. So it might be used to kill aphids. It might be used in another formulation to kill mosquitoes, depending on how it's applied. And so for them, the blanket ban really puts our agriculture and in another way, our health at risk. And so they wanted to go with a definition that's used in federal law under some other stuff, which was a problem for the proponents. What we finally did is decide that they weren't going to come to a nexus. And so we came to one. Neither of them is particularly happy, although the ag people have said that they could go to neutral with it. The proponents, including the Academy of Pediatrics, have notified us if we go with that definition and what we have, that they will take their support away from the bill because it's not helping enough people. It may only be getting 6 chemicals out of our PFAS stream. I think for me, and I don't want to take the liberty of speaking for Delegate Hutchinson or Warman, I think a start is a start. And again, these are more dynamic chemicals. And in fact, they're supposed to be toxic, right? They're cidal. They're supposed to kill bugs. And so I believe that starting with that definition and giving the Secretary of the Department of Health, based on emerging and new health concerns, in coordination and agreement with the Secretary of Agriculture, based on use needs and available alternatives, to be able to add to that list, allows us to get started and to continue to prioritize health concerns. And I think it's better than nothing. And, we can look as the years go by and build upon that as more science comes out or as we feel a need to.
Thank you, Delegate Hill. And I saw Delegate Hutchinson, you unmuted. Go ahead.
Sure. And so I think it's also important to note that we do have the definition of PFAS, and that has remained in the bill. But what we've added is a working scope that is specific to pesticides to accommodate this bill. So, you know, we really have looked at this, I think, at every possible angle. This will initially eliminate 6 PFAS, and then it does open up the door for the Department of Agriculture, along with the Department of Health, where they may, add based upon the new and emerging health impact data or the evolution in needs, uses, and availability of alternatives. And then it does push it out to 2032, which is also consistent with Maine and Minnesota as well. And by pushing that out, initially we had the ability for the Department of Ag to ask for waivers. But because we have pushed this out and the changes that we've made with the unavoidable risk, we don't have the need for the waivers any longer.
Thank you, Delegate. And just for my edification to make sure I understand too, and the body understands, we're not calling on the departments to do the science or do the studies, just if there is emergent science that they want to respond to, and or alternate non-PFAS pesticides that industry has identified and created, that they would have the authority to take action without having to bring a bill back. Is that
Correct?
And
Yes, and if I can just note, I think at one point, well, I know at one point the proponents were suggesting, well, perhaps we could just, stick with the bill for schools and vulnerable people, so it couldn't be used around schools. But again, it doesn't take into account why we use the chemicals at all. And I think it's really important that we recognize that we're trying to balance health impacts, cumulative health impacts. So if you're exposed to a PFAS, because your lawn gets sprayed, twice a year, that's very different than if you're being constantly exposed because you're playing on the lawn or whatever. So I think those are things that the Department of Health and I can take into account. And as I said, a start is better than no start at all.
thank you. And am I correct? Because again, I know we're all just looking at this, and I'm doing things a little out of order because I haven't called on council yet. But I just wanted to understand. I wanted us all to understand the work that has preceded this. That the working scope, does that also have a sunset so that we're revisiting it?
It does not.
It does not.
Can't. I think we talked about putting that in it, but we did not. And to Delegate Hutchinson's point, I don't think that the amendment, I'm not sure the amendment language as introduced did what he said, which is keep the definition as in the bill. And I thought we substituted that working scope, but Aaron can do that. And I don't know if Delegate Warman wanted to add anything.
Delegate Warman said that she's good. She's
No,
a
you
me.
guys got it.
She's a me too.
Hang on, just a clarification. So when you do get the reprint, you'll see where the definition does remain
Okay.
on page 3, number 3. It does remain there, and then we add the working scope to that. And I think it's important to note, particularly because the Department of Health is in here, that the word may, that the Department of Health, along with the Department of Ag, may prohibit additional PFAS resources. So it's not that they are held responsible for having the staffing and understanding of each of the PFAS issues that are out there.
So this is enabling them, giving them the authority to act without legislation.
Correct.
Because it's retained in the legislation. And if I understand it, we're retaining the Maryland definition, but creating a working scope for this specific
pesticides.
use. Okay, thank you.
Right.
Um,
Last one, I know we have to move on, but I was just gonna add that I know a lot of times we say if everyone's unhappy, then it must be a good bill. I don't think any of us feel that way. We're not happy that neither side or only one side seems to be okay with it and the other side seems to be very upset. But we're asking the committee to make an executive decision, because it's really our job to do the hard stuff.
Thank you, Delegate Hill. I'm going to turn to council and see if there's more to consider, or if we've encapsulated to your satisfaction what we're talking about.
I can do a quick walkthrough of the reprint. So
That would be great.
has an idea.
Thank you so much.
Sure. If you look at the reprint, the crux of the bill begins on page 3. It defines active ingredient, it defines PFAS chemicals. And that was one of the things that we've been discussing. A PFAS chemical means a class of fluorinated chemicals that contain at least one fully fluorinated carbon atom. Don't know how to pronounce these words, including these 2 substances. And then that also include certain specified chemical compositions. PFAS pesticide means a pesticide that has PFAS chemicals listed as an active ingredient on the labeling. The Maryland Department of Agriculture must develop and maintain a list of each PFAS pesticide that is registered with the Secretary of Agriculture in accordance with the bill. On or before January 1st, 2032, the Department of Ag shall post the list developed under the subsection on its website, distribute the list to all certified applicators. And then beginning June 1st, 2023, a person may not use a PFAS pesticide listed by the department at a healthcare facility, a school, a daycare operation, for residential lawn care, or for commercial mosquito spraying operations. And then before June 1st, 2023, the Department of Agriculture must notify all certified applicators of the prohibition. And beginning June 1st, 2032, the department may not register a PFAS pesticide for sale in the state. And then beginning June 1st, 2032, a person may not use a PFAS pesticide in the state. The Department of Agriculture, in consultation and agreement with the Maryland Department of Health, may prohibit additional PFAS chemicals based on new and emerging health impact data and evolution in the needs, uses, and availability of alternatives.
I apologize. If I might add, I got the reprint out to the subcommittee very late since we received the reprint probably 5 minutes before subcommittee convened. So if anybody did not receive that and need me to resend it, I can do so.
Can you send it to me? And I'd like to move the amendments for discussion.
Second.
Sorry about that. My computer froze. So was that was a motion on the amendments? They've been moved and seconded. All right, we'll go ahead and open it for discussion. I see a hand from Dr. Ignowski. I want to make sure I'm saying that correctly.
Yeah, it's Ikniowski, but that's
Igniowski, thank you.
Yes, I'm here representing the Maryland chapter of the American Academy of Pediatrics. The problem that we have with the bill is that it doesn't sufficiently protect children from the effects of the PFAS pesticides that are not covered by the working scope definition. In the amendments, it says that the one carbon PFAS definition does not effectively communicate risk, and the working scope definition does not communicate safety. So I think that given the studies that we sent to the committee demonstrating the health effects of many of these one carbon PFAS pesticides, that there is a need for greater protection for child health than what the bill as presented with the amendments would provide. The other potential problem that we see is that by introducing the user-specific scope into Maryland legislation, it sets a precedent that would allow bypassing other PFAS chemicals in future legislation and limiting it to a user-specific group favored by the chemical industry, rather than giving full consideration to human health and child health in particular.
And would we, anyone who was on the work group, would you care to respond? Or anyone who can appropriately respond? Because I do know that we thoroughly considered the science, and you don't have to convince this committee of the science. But we are trying to create a balance. We are trying to create a balance. Ms. Thompson.
Thank you, Delegate. I apologize, I can't be on camera right now. I'm outside a committee hearing. But in response to that, just to clarify, the working scope that is being implemented here is in fact the definition that is in place for PFAS by EPA under the Toxic Substances Control Act. They passed it in final rule in October of 2023. And has been adopted as a working scope by the Office of Pollution Prevention and Toxics, as well as the Office of Pesticide Programs. So this is not a industry definition. This is the federal definition that's currently in final rule. And then to the point of further evaluation, I think that one of the compromises that we are willing to make as the opposition is that this bill does allow for the Department of Health as well as the Department of Agriculture to evaluate that emerging health data in order to make the decisions based on sound science and their evaluation of that data.
And Ms. Thompson, do you know nationally how many states utilize this working scope from the EPA as it relates to pesticides?
So currently there are 2 states that have adopted this EPA definition more broadly, and that would be Delaware as well as West Virginia. And then the caveat to that would be that there are only 2 other states that have utilized the broader definition that includes pesticides currently. That would be Maine and Minnesota, but that there are 27 other states that have adopted PFAS legislation that specifically does not address pesticides because of the federal regulatory framework that's in place.
So other states are simply silent on this. Is that?
So there's 2 states that have this definition in statute. And then there's other states that have the 1 carbon definition, but it does not apply to pesticides.
Okay, so they're excluded from that. Okay, thank you very much. Ms. Schmidt-Perkins.
Thank you very much. I really appreciate this, representing Maryland Pesticide Education Network here on this call. I really appreciate how much time this working group has spent on this issue, many early mornings, blurry-eyed, really giving a lot of thought to this. I do want to point out on the topic specifically about this definition, a number of states have had this definition come up and they've rejected it. And they include Connecticut, Rhode Island, Indiana, California, Maine, Massachusetts, Minnesota, New York, and Colorado. So the 2 states that we've sort of been looking at that have PFAS pesticides as part of their program have rejected this definition. It's also been rejected by scientists worldwide by every advocate, because what it does is, these definitions, but to be clear, in the case of what we're looking at here, it takes 66 PFAS, which we identified off an EPA database. So EPA says the PFAS pesticides, and it would reduce it to, I think it's like 5 or 6 that are very rarely used in Maryland. So it's literally wiping out many of the products, which we have some concern in Maryland about what kind of harm they're doing when they're used in neonatal situations, and dentist office, and daycares, and mosquito spraying, on lawn care, all the different uses that we do this. So this definition wipes out all uses of PFAS pesticides virtually in Maryland. So the intent of the bill is to actually try to do something about it, and that's clear that this committee wants to do it. But it has to be a bottom line for all the scientists engaged in this, all the environmentalists engaged in this, all the medical people have been engaged in this, that this definition removes the protection from these most harmful chemicals for Marylanders. And that's why we've been so vehement that we're willing to work on any number of ways to negotiate through this, but we can't undefine toxicity. And as Mike just said, neither one of these definitions actually are about risk, they're about defining. So neither one of them saying one doesn't do it, well, the other one doesn't do it either. So, I mean, this is hard, this is complicated stuff, and it's hard to wrestle with, but it is this, I mean, this committee's heard from 30 environmental groups, 163 scientists, PFAS experts, that this definition is a problem. So it's a pretty important issue for us. And again, we're willing to look at any number of things, and Delegate Ruth and I have brought any number of different options to the fore to try to navigate our way through. We continue to want to do that, but we simply can't define our way out of the toxicity of this. Thank you.
Thank you, Ms. Schmidt-Perkins. And I will remind the body that we are coming up on crossover. So we as a committee can make a decision. And I'm going to go to Delegate Hutchinson.
Ms. Schmidt-Perkins, those states that you mentioned, are those pesticide-specific bills that they have?
I don't know the answer to that, Delegate. Thank you for the question. It was specifically in Minnesota and in Maine where they are addressing PFAS pesticides, and they rejected this definition.
Yeah,
so, that's what we've been looking at a lot for modeling in Maryland.
Those other states don't have a pesticide-specific bill. And also, the EPA doesn't define them as PFAS pesticides. They identify them as fluorinated pesticides.
By definition, on their website, they actually call them PFAS. They do on the website, they label them as PFAS. It is very confusing. I will.
Do you have a follow-up, Delegate Hutchinson? Okay, Delegate Chisholm.
Just for the record, the PFAS up in Maine they're worried about is from the wind and solar fields. So there's a lot of PFAS in solar and in the wind turbines. That's what the big lawsuit in Maine is all about, all the solar fields and being concerned about the PFAS going in those fields, not necessarily farming.
Thank you very much, Delegate Chisholm. While we've got, where we've got our stakeholders and our expertise here in the meeting, I just want to see if there are any other questions from the members. We do have a motion on the amendments. They have been properly moved and seconded. Any further questions or discussion on the amendments? All right, all in favor, say aye. Anyone opposed to the amendments, go ahead and raise your hand in the chat. All right, do I have a motion on the bill as amended?
You should move the bill as amended.
Second.
All right, it's been moved and seconded. Do we have any further discussion? Discussion. You can tell where we are in session. Any further discussion on the bill as amended? Delegate Riley. Oh, you need to unmute.
Yes, thank you, sorry. In the amendment, when it talks about at healthcare facilities, so because we've had some PFAS bills in the past. It looks like this particular bill is, like you're saying, we're kind of focusing on the pesticides and things like that. But in the list for, to where we have to kind of like eliminate by 2032, and you have at healthcare facility. Does that include like all the medical equipment that we have companies that actually make medical treatment, medical products, prosthetics? That's all made from some form of PFAS. There are all these like really long names. I don't know if the definition in this one would affect those companies. Do we know?
Delegate Hill can probably answer this, but I don't believe so because this is
Okay.
specific to PFAS
To-
pesticides.
Right. Okay.
Delegate Hill is
Yeah, Delegate Rowley, if you read just above that, line 20C1, it says beginning June 1st, persons may
Mhm.
not use a PFAS
Yes.
pesticide
Okay.
in those facilities.
In those facilities. So it has nothing to do with medical equipment.
Correct.
No,
It's
I
about
appreciate
when to use
the
pesticide.
question.
Okay, thank
Absolutely,
you very
but
much. I
it's
appreciate it.
very, very specific to pesticides, which is
Yeah,
why we're able
that's what I
to-
thought, but I just wanted to clarify. Thank you.
Absolutely. Thank you for the question. Are there any further questions on this bill as amended? All right, all in favor say aye.
Aye.
Anyone opposed, go ahead and raise your hand in the chat. Thank you very much. House Bill 386 passes unanimously. We have one more bill to consider, but I don't see I see the department. Oh, yeah, I see the department. I see the ACLU. So this is House Bill 290. We had the discussion in our previous meeting. Also, I do want to say before we move on, thank you so much to Delegate Hill, Delegate Hutchinson, Delegate Warman, and to all the stakeholders for the multiple meetings, and for Aaron for always making yourself available. When I came to you and asked you questions and sent you amendments. House Bill 290, this was the Office of the Chief Medical Examiner, disclosure of autopsy information and maintenance of investigative database. We had the discussion, we had some amendments moving, but we did not have consensus, and we brought in the ACLU for response. So Delegate Hill, do you want to start us off? Because I know you were leading some of those efforts, and then we can hear from our stakeholders where we are.
Sure. So if you all will recall, 290 is a bill that would change the information or change the initial information that a public information request to the coroner, the chief medical examiner, would get. And the concern, and the health department can speak for themselves, was that they did not want to disclose personal information that personal information, recognizing that information about how someone died does have, that there's a public right to that, particularly when it's a public person or there's a public death, right? It doesn't have to be a public person. But they also recognize that the people who make PIA requests are not always public people. It can be family, it can be enemies, it could be neighbors, it could be anybody. And they were trying to, as I understood it, to walk that line. The opponents, and at the time of the hearing, we heard mostly from the journalist, and we have subsequently heard from the ACLU, are concerned that if you do not have full autopsy information, it is too easy to disguise the true cause of death. And they were concerned that the medical examiner, for whatever reasons, political, or otherwise might be making decisions about what information to be released under the cloak of privacy that really serve to suppress the truth about the death. And that's my summary of it. And so I think both sides, and the ACLU was not involved with the discussions, but the journalists and the the Department of Health, I think, worked in good faith to try and find a process by which there was minimal holding back of information while protecting the privacy of patients. And some of that is about what is released and some of it's about the process. And part of that had to do with recognizing that we're really probably talking about at least two different actors. Journalists being, one type, whether they're official journalists or not, who are actually looking to get information to determine whether there is any information that needs to be obtained, versus someone who simply wants to know, for other reasons, personal reasons, family reasons, what the cause of death was. But even in those cases, sometimes you think that the death was accidental, and it's only when you get the deeper autopsy report that you find out that there was something else going on that if you had known about it, you might have changed, how you approach the death or any investigations into the death. So that was way too much. Let me stop.
Thank you, Delegate Hill. Aaron, do you have a reprint for this one? Okay. So let me go to Sarah Case Heron.
Thank you. And I will say we did actually reach out to the ACLU. I will, in full disclosure, and I know Ms. Johnson will acknowledge this. We were not able to come to consensus with the ACLU, but we did meet with them earlier today. So we have been making the effort to come to consensus. And I do want to just add a few points of distinction to what Delegate Hill stated, which I think was in general an excellent summary of kind of where we have come and where we have been. But I want to add that it's not just the autopsy reported diagnosis, because again, we understand the public interest in some of the documents, but we also have a database with additional information that is unrelated to the cause of death. And there are investigatory records that are unrelated to the direct diagnosis of the death that have private information that, because it is not part of that public interest in understanding the cause of death, we are seeking to protect with this bill. So what we have done and where we have made an effort to come
See
to
if you can get MDH on the phone today. Or send it to him.
Come to consensus with is to more specifically delineate what would be public through the PIA process, and to clarify what we mean by the autopsy diagnosis and the pieces that would be provided under PIA as delineated from other records that we would seek to make a restricted record, but still available potentially under a data use agreement when there are cases of public interest and there is the ability to protect that data. So one of the things that, and I don't know if the full committee has been able to see them, that we have done is add to the list of what would be included in the autopsy diagnosis, again, what would be available under PIA, in addition to the name of the decedent, the age of the decedent, the gender of the decedent, race of the decedent, cause and manner of death, including, if applicable, a list of drugs that caused or contributed to the death, the medical opinion of the facts informing the conclusions, and both, because we understand the efforts to create, have that internal versus have those facts, the external and internal examinations, including evidence of injury. So all of that would still be available through PIA. It's additional unrelated information that's unrelated to the cause of death that we would be seeking to protect. And I'll pause here and see if Dr. Dean, who is also on, has anything to add.
Go ahead, Dr. Dean.
Hi, so thank you, Madam Chair, and thank you to Sarah and Delegate Hill for those summaries. And I would just reiterate the same. So what we sought to do was to essentially define what is the autopsy report, which is something that is currently lacking in the law as it's currently written. That allows us to keep that transparency that everyone is so used to. So getting the autopsy report, pages 1 through the final page, which has the pathologic diagnosis, so the summary of all of the findings of the medical examiner and their medical opinion as to the cause and manner of death. But by doing this, it also allows us to protect that confidential medical record, those other records that we do have pertaining to each decedent, again, that Sarah alluded to. So we're talking about personal details of surviving family members, addresses, names, phone numbers, infectious disease testing of the decedent, so that important information we would seek to protect, but again, just better define what constitutes the autopsy report, which is currently, accessible by the PIA. And also seeking to clarify that this does not limit any discovery rights. It should not impact any future audits. It does not impact an attorney's right to get the materials that they are entitled to. And it does not impact the right of family members and persons of interest to get the information that they're entitled to as well.
Okay, thank you, Dr. Dean. Let me go. I have a hand from Delegate Hutchinson.
Thank you. It's probably for Dr. Dean or maybe for Sarah, but it's been a while since we've seen this bill. Just remind me, what's the problem we're trying to solve here? Why is this bill in front of us? Why are we here today?
So I think the problem is that without this definition of autopsy diagnosis, unrelated facts that may end up in the chief medical examiner's database and private health information that is unrelated to the cause of death could potentially be public. And I think one of the important points that Dr. Dean made when she was testifying is that decedents are still people, and so we do still want to protect the aspects of their medical history that are unrelated to their cause of death. And also we have other information, addresses of next of kin, things like that are not really part of that cause of death, and that we want to keep from being public, if at all possible, to protect those privacy issues.
Thank you. Let me go to Delegate Alston.
Go ahead, Madam Chair.
Well, I was going to say, I'm just for the edification of the body, because we don't have a reprint, I am going to hold this bill, but I want to make sure we're having the full discussion while we have everyone here. So I was going to go to Ms. Snyder, but Delegate Alston, did you have a question before I go to Ms. Snyder?
Well, my question for the department is, why can't you all do this under the current law through redactions?
And I think the answer to that is that we have tried, and sometimes in the past we have been overruled with those redactions because the definition of autopsy report was not clear. And so the piece there has sometimes allowed information that we believe would be more private and unrelated to the cause of death to be released.
But a court has examined it and determined that it should be public. Because you said you were overruled. I'm by a court.
Yes, because of that. Because we would say that the definition of what was included in the autopsy report was not clear. Would be our yes.
Thank you.
Thank you, Delegate Alston. Ms. Snyder, go ahead.
Thank you. So the real problem here is that we want to make sure that the information that surrounds that's not necessarily related to the cause of death, and Dara can talk to this more directly in what's happening with the audit and some of the police custody deaths and other things that are happening. But sometimes there's information that that the public needs to know. Like if there's, for instance, a police-involved shooting, you need to know what drugs are in that person's system, even if the bullet is the thing that killed them. And so we feel like, and we have worked very diligently with the department on amendments that we feel preserve the transparency. We're not all the way yet, and I think you all received the email from me to say, you know, where we're divergent from MDH on this. But in general, we do want there to be more transparency. Maryland has historically been really focused on, has had really open autopsy reports. I don't disagree that, you know, next of kin information, there's some things that maybe shouldn't be out in the world, but when we get into, I don't think it's as simple always to say, these are the fields that are always going to be appropriate or not appropriate because the circumstances change for each person. And so I'm really glad to see the subcommittee having this debate. And I think the ACLU can certainly talk about some of the nuances that press doesn't have that really prompted their concerns with this bill.
Ms. Johnson.
Yes, thank you. And we do appreciate Sarah's outreach on behalf of NDH, but unfortunately, as mentioned, the proposed amendments just don't alleviate our concerns when it comes to the limitations that this would place on transparency. Like Rebecca spoke to, there is a audit by the Maryland Attorney General's office that, in our understanding, is still pending, is still ongoing since it was started in 2021 of the OCME, and this started following the trial of Derek Chauvin, who was on trial for the murder of George Floyd. And there, the former chief of the OCME, David Fowler, offered testimony where he said that he would have assessed Mr. Floyd's death as undetermined rather than as a homicide. And subsequent to that, based on just outrage expressed by hundreds of medical experts as to how that was a deviation from medical standards from in that field, there was an investigation launched, an audit launched by the Attorney General's office. And currently we understand that since the team issued a report in 2022, recommending that there be independent review of 100 in custody deaths that particularly involved restraint and were assessed under Dr. Fowler, that is still ongoing. And so with that, plus just the other examples where it's not just as to the cause of death, but also, as Rebecca talked about, the manner of death, the circumstances surrounding that where, you know, how an examiner might determine a cause of death to be, for instance, asphyxiation, and the manner of death to be asphyxiation due to a certain using a certain tool. The circumstances that might allow for that that are extremely important, not only for that person's family to understand, but for the public to understand in terms of preventative actions that can be taken, measures that could be taken to address that. That's what those facts are needed for. And when it comes to organizations like us, requesting that information in the public interest, as opposed to someone who, even with this bill, would still be able to have access, such as a state representative. In those circumstances, when a family is grieving, when there are deadlines, when it comes to what a family can do, which is now appeal a OCME determination, when there's just a multitude of reasons why, you know, a particular family might not at that time want to request those records, but why they might still be very important to obtain, both to assess that incident, but also any patterns that might contribute to understanding causes of death regarding the particularly critical deaths that the OCME assesses. That's where advocates like us and other folks we are concerned for, who might be less savvy around the, you know, proposed data sharing agreement and things of that nature. We just want to make sure that at least until the results of this audit are known publicly, that we're able to maintain that transparency.
Thank you, Ms. Johnson. I understand the challenge is to be how do we create consistency when we also are looking at, we need to see everything to know what is relevant. Is that kind of and we're trying to find the balance that exists so that the department can proceed, and that we're still creating the transparency that is in the public interest. Let me go to Delegate Hill.
Thank you, Madam Chair, and thank you, Ms. Johnson, for that. I wanted to ask Ms. Case-Heron to respond and actually ask a question. I maybe we asked it in committee. I don't remember the answer. What was wrong with what you were already doing, the medical examiner was already doing, and why does it have to change? Because I think she makes a really strong case for why we want as much information as possible.
So thank you for the opportunity to respond. And I will also tap Dr. Dean. And I'm going to apologize because I turned my camera off and now it does not appear to want to turn on. So I apologize for the technical issue there. But I think one of the flags that I will have here is that we're not just talking about the autopsy report. We're also talking about additional information that's in our database that's not part of that death diagnosis or that diagnosis. And I will also note that in addition to adding kind of the additional information to how we would define that autopsy report and diagnosis, we do create kind of this data sharing agreement. And I think that the point for us and one of the flags here that we worry about with the kind of prior process is, while the cases that
I'm sorry, what was the prior process?
The prior process was that was the normal PIA process with autopsy not clearly defined, and therefore potentially allowing for autopsy report to include additional information, unrelated, like things like, as we mentioned, next of kin addresses, medical history unrelated to the actual death, and things like that. I'll also pause here and see if Dr. Dean wants to add any more there, but those are some of the examples. Those potentially could all be challenged as part of PIA previously, and we had no way of clearly delineating what was in the autopsy report because it was not previously well defined. And so the definition of autopsy report was, we believe, missing, or it has been missing from the statute. And so while it was clear that the autopsy report was available to the public, and we want to maintain the records that are part of the autopsy report as being public, these other records that end up in our database but are not related to that autopsy report and diagnosis could potentially be pulled in because of the lack of a clear definition. And I'll pause here and also let Dr. Dean weigh in. Again, apologies for the video issue.
So I can add to what Sarah had to say as well. I think that what isn't working, or what wasn't working, was the uncertainty regarding what constitutes the autopsy report. For us as an agency, depending on whoever our legal counsel was, or whoever we were asking for legal advice could possibly interpret it differently than somebody else. And as an agency and as a state, that puts us at risk for releasing things that probably shouldn't be released, depending on any certain individual's interpretation of the law. So that's where better defining what constitutes an autopsy report we felt was needed in the law, and to be able to, of course, like I said, keep continuing to release the autopsy report as public record, but again, define what that actually means. Additionally, our agency was developed in 1939. We did not have a database at that time, and currently it exists nowhere in the statute. So that was the addition of the database and the theory behind what we need to protect all the sensitive information that has over the years been stored in it.
If I may, Madam Chair. It just seems to me that now that we've fleshed that out a little more, that it would have been a lot easier to exclude demographic information than to try and narrow down what you mean by autopsy data. Unless you're saying because all the things that Ms. Caseron has described as demographic information about people other than the decedent. And if there's other information that you feel like you should protect, I think it would be helpful for us because I'm getting a sense that the ACLU case is pretty strong right now. And it just seems like this is a weird way to go about shielding demographic information.
All right, I'm going to go to Delegate Alston, and then I do want to conclude because I want to give our stakeholders another opportunity to try and get to consensus because I am going to hold the bill today. And I also know that we have another subcommittee, I think, that has to meet. So Delegate Alston.
Yes, I'm just wondering, you mentioned litigation. When you all went to court for withholding information and the court found that you should have released it, did the court opine as to what their interpretation of the autopsy report was? And if you're not sure, if you could just tell me the name of the case so I could read the findings and holdings.
We can provide that case. I will need to get that information for you.
I'll
Okay.
email it to you.
Thank you. And then I have another question, if I may, Madam Chair.
Go ahead.
Okay, are you all still under this audit that the ACLU mentioned with the Chief Medical Office? Medical Examiner?
Yes, the audit, to our knowledge, is still ongoing. And the last communication that we had from the Attorney General's office is that they are nearing completion, but they understandably are doing that audit independently. So we generally don't know what the status of it is.
Okay, thank you.
Thank you, Delegate Alston. I want to go ahead and conclude, but we are going to have at least one more subcommittee, so stay tuned. Thank you all for your patience, for your flexibility, and for your hard work, because I know you all have been really burning the candle at both ends. And so thank you also to our stakeholders for making yourself available to us and to answer our questions and making yourselves available to each other so that we can get this done. Thank you very much. With that, we are adjourned.